started recording. So welcome everybody. So this is our second in the series of CPD in 43, COVID-19 force majeure, from Ben Priest of Quadrant Resolution Limited. He'll be taking us through basically a lot of stuff that's been happening this year. And it'd be really interesting to hear what's been happening on a contractual basis. So I'm Usman, I'm Vice Chair of Wessex, SciAT Wessex, and we've basically pulled together a series of events with people like Ben, all the way through to the end of next year, all virtual, hoping that some of them might be able to be physical at some point in the near future, but for the moment, absolutely every single one will be virtual on Teams, and hopefully everyone finds each and every one of our events of use. We do have a couple of others that are coming up in our diary. Hopefully you can see those on the screen. We've got a tangent of the series that we've got in is CPD in 43. We've also got in discussion with, so we've actually got Paul Smith, who is the immediate past housing cabinet member of Bristol City Council and also now CEO of Elim Housing, who'll be talking about what is the future of housing in Bristol. That is on the 16th of December. And then when we come back from our Christmas break, we've got another presentation which is in discussion with, which is on the 6th of January, which is with Kaylee Fazan, who's basically someone who can help with personal growth, CV advice and job advice, etc. And just to learn to how you guys can grow and how you guys can make more about where you are and how you might be able to grow in the future. So I'll stop talking now and I will hand it straight over to Ben. Ben, welcome. Please do a little introduction if needed, and then also get cracking, and we're really interested to hear what you have to say.
Great, thank you, Usman. So I'm going to try and share my screen now. And hopefully you can see my welcome screen. Thank you. Great. So yes, welcome everybody. And first of all, thank you to the Institute for inviting me to talk today, and in particular, thank you to Usman. And I will start with a little bit of an introduction about Quadrant because it'll help explain the context of my talk. So my name is Ben Priest and I'm a director at Quadrant, and Quadrant is basically a construction law consultancy. So we draft professional appointments, contracts, warranties, and all the other various documentation that we need in order to be able to set up a construction project properly. And we also deal with sort of the darker side of construction as well. So account disputes, final account disputes, adjudications, arbitrations, defects claims, and so on. You'll also see Law Hub in our branding, which is sort of a retainer service that we provide training and support to clients with. So basically, we've seen COVID-19 and its impact on the construction industry from a number of angles, from the developer side, from the professional side, from the contractor side. And one of the things that came up at the sort of towards the start of the year in March was force majeure, and contractors were asking me, well, you know, we've been delayed, we're not on site, it's a force majeure, isn't it? And it would then become apparent that actually they didn't know what force majeure was, other than it generally being a sort of get out of jail card. So what I want to do is deal with what is force majeure. And in addressing force majeure, I need to actually talk about the concept of frustration of contracts. And I'm going to do that. Then we'll take a look at some of the most common forms of contract, and then what we've actually experienced in practice. So the first question is then, well, what is force majeure? And generally it refers to an event which is outside the reasonable control of a party to a contract and which prevents that party from performing its obligations under the contract. Now, it's important to note, and you can probably tell it from the description of, I'm just going to pause for a second because my slideshow is taking me forward automatically. I want to sort of stop that from happening. And just wondering how best to do that. So if I go perhaps to reading view, will that give us a better? That's better. Sorry, I'm back in control now. So yeah, I was just talking about force majeure and how you can tell from its name, it's not an English common law concept, and instead the English common law has a concept of frustration, which I'm going to talk quite a bit about in a moment. And so there's a number of important points because of that. So I'm still being cast forward. Anyway, the can I stop this end show? Well, we'll just look at it like this. Hopefully everybody can read the slides and it'll stop distracting me. So basically, as I was saying, there's a number of important points about it not being in the English common law. The first point is that it won't be implied into a contract. So if your contract does not mention force majeure or does not deal with unforeseen circumstances, the English common law won't imply force majeure into it. The second point is that because there's sort of no implied terms about force majeure, what actually happens and what impacts the parties is totally dictated by what the force majeure clause will say. And we're going to come on to that in particular when we look at the JCT contracts. So to set force majeure into context, and I've already mentioned it, I want to talk about the doctrine of frustration. Now, this is an English common law concept, and basically the doctrine of frustration applies and ends the contract if the event that we're talking about is not the fault of either party to the contract, the event occurs after the formation of the contract and was not foreseen by the parties, and it becomes impossible to fulfill the contract or transforms the obligation that the party has to perform under the contract into a radically different obligation. And I stress radically different because it's not enough for simple delay or inconvenience. The event really has to go to the heart of the contract, to the purpose of it. That leads me on to a couple of sort of key points about frustration. And the first one is that it is all or nothing, really. Frustration will end the contract, and so the parties to a contract will no longer be bound by it. And what that means is that basically contractors in this example could not use frustration to gain extra time or money. You can't use it for an extension of time. You can't use it for loss and expense because the contract isn't continuing anymore. From a legal perspective, the project is over. The contract's at an end. So it's got quite dramatic. It's quite a dramatic impact, and because of that dramatic impact, there's a very high evidential thresholds because you have to be able to show that the event which is causing the frustration of the contract actually stops it from being performed. Again, as I say, delay, inconvenience isn't enough. The final point on the slide I've got on the screen is a bit of a technical one, a bit of a legal one, and that is if there's a force majeure clause in the contract, the contract won't be frustrated. And this goes back to the force majeure event needing to be something that was not foreseen by the parties. So if you have a clause in a contract which deals with force majeure, the unforeseen events, well, effectively you've catered for it. And so rather than the contract just ending and being frustrated, the terms of the force majeure contract will apply, and that will dictate how the contract is dealt with and any losses and that sort of stuff which flow from it. So before I go on to force majeure, I do want to answer, is COVID-19 then a frustrating event in the legal sense in the construction industry? And I am talking about the construction industry here because whilst we're looking at the legal concept, the facts do matter. And at the sort of start of the year in March, the government obviously did various things. But one of the points which sticks out for me is the Secretary of State for Business, Energy and Industrial Strategy issued a letter on the 31st of March 2020. And within that letter was a paragraph which I'll quote. And it says, "The government has advised that wherever possible, people should work at home. However, we know that for many people working in construction, their job requires them to travel to their place of work, and they can continue to do so. This is consistent with the Chief Medical Officer's advice." So basically, on-site construction operations could continue. And talking generally, no, COVID-19 was not a frustrating event within the construction industry. It did not stop on-site construction, and so would not bring the contract to an end. I say I'm talking generally here. So looking at frustration, I now want to sort of get back to the main point of the talk, which is, well, is COVID-19 then a force majeure event? And the answer is basically along the lines of the lawyer's kind of typical get out card, get out of jail card, which is that it depends on the contract. And I don't want to be accused of sort of trying to sidestep the answer to the question by just leaving you on it depends on the contract. So what we're going to do is actually have a look at some of the most commonly used standard forms. And I'm going to start with the JCT, and in particular, the JCT's design and build contract 2016. And I'm not going to go into the mechanism for the extension of time. Many of you will already be familiar with that, but essentially it rests on a number of listed relevant events. And those looking at the slide or just simply familiar with the design and build contract will say, well, yes, it's obvious that COVID-19 is a force majeure event because force majeure is listed at number 14 of the relevant events. So COVID-19 is force majeure is listed, so I get my extension of time, please. Now, the issues we got here and why I would urge caution on it is firstly, force majeure isn't defined within the JCT. It's not a capitalized definition. So the courts would be left to interpret what this means. And here we have a difficulty going back to sort of the start of my talk, because force majeure isn't an English and Welsh common law concept. And as such, you haven't really got complete certainty as to what the court would say. Also, looking at force majeure and sort of the seriousness of the event, it can be looked at being sort of akin to frustration, where it's such a serious event, it could bring the contract to an end or substantially stop it. Well, here I've already quoted the Secretary of State's letter. The problem was often that whilst construction could carry on, it had to be carried on in a different way. And I'm just going to flick forward. No, sorry, actually, it's on this screen, which is the CLC's site operating procedures, which obviously included various different practices to site working, which meant that contractors could carry on with their sites, but often the working would be less efficient because they had to keep distances. They sometimes had to double handle materials and things like that, which they otherwise wouldn't have had to have been, had to spread out more, etc. So you've got an issue where the event might not be as dramatic as what the court might view a force majeure event to be, because the work can carry on, but nonetheless, it is causing delay. And so I've also put on this slide number 12, which is the exercise after the base date by the government or any other body of any statutory power. And I'll just stop there. So statutory power is wider than an act of parliament, because I know there's been some controversy over the last year about how much parliament has been involved, but we're talking about statutory power here. So it is wide, and importantly, it's not occasioned by a default of the contractor or the contractor's persons. So the government basically bringing in rules that dictate how site operations were to be carried out, therefore slowing down site operations, potentially, I would say, is perhaps a safer one to rest on. And any contractors will no doubt run both arguments in parallel. So that's the time side, and in summary, yes, I think COVID-19 JCT, you're pretty safe on the time side. Now, because it's a JCT, you've got to then look at the money side separately. And again, I'm not going to go into the loss and expense mechanism in detail, but again, it rests on relevant matters. Now, in the list of relevant matters, there's no equivalent number 12 or number 14. So it hasn't got the statutory powers and it hasn't got force majeure. The thinking basically being, or the intention seems to be, that will shield the contractor from liquidated damages and give him some time, but he's not going to get any more money. And that, I think, in most circumstances will be the case. But I do want to flag up that I have seen a number of projects where either the developer or whoever is the end employer, for whatever reason, sometimes commercial, hasn't wanted the development to continue. They've paused it. In some instances, it was so that design could catch up with the works, and in some cases, sort of changed the development. Well, you've got change being a relevant matter, and you need to look at that and the definition associated with it. But change could get the contractor money. Also, what I've been saying about it not being a frustrating event, potentially not being a force majeure event, would equally imply to the employer. So if the employer has chosen to keep the site closed, even though they didn't actually need to under the rules and legislation at the time, that could easily be an impediment, prevention, or default that could entitle the contractor to money. So in summary, it's most likely under the JCT that the contractor will get time, but not money. But it's not entirely closed off, and you do have to look at the circumstance on each project. The next main sort of standard form contract I want to look at is the NEC, and in particular I've looked at the NEC 4, and with the NEC you've got kind of the one-stop shop of the compensation events, and it's not labelled as a force majeure clause, and if you do Google searches online, many of the articles will say the NEC doesn't have a force majeure clause in it, but actually, when you read it, there's a lot of the similarities, the characteristics with force majeure. So there's a compensation event, which is an event which stops the contractor from completing the whole of the works, or perhaps more relevantly in this case, stops the contractor completing the whole of the works by the date planned for completion shown on the accepted programme, and which neither party could prevent, and an experienced contractor would have judged to have such a small chance of occurring, and is not one of the other compensation events stated in the contract. So here, you've got, as I say, because it's a compensation event, it captures both the time and the money. And you would have to say that COVID-19, or the effects of it implemented by the government, would and could have delayed projects, not in every case, of course, but certainly had the capacity to do so. Neither party could have prevented it because they were dictated to by the government, and it's unlikely that an experienced contractor could have so anticipated the scope and the scale of the problem, and it's not one of the other compensation events stated in the contract. So I would say there's very strong grounds for COVID-19 to be a compensation event. And really the debate to be had with any contract administrator, which the contractor, is about the facts. You know, did the contractor mitigate the delay? Did they do everything that they could in order to progress the project, and so on and so forth? Also in terms of costs, you know, what are the actual costs that have been incurred? I do also flag up at the bottom of this slide as well that there is an optional clause as well, which is to do with a change in law. Now, if that option clause is selected as to apply, there may be capacity for the parties to rely on a change in law as being a compensation event. But what I would caution there is the wording of that compensation event is more narrow than the JCT's simple change of a simple exercise of a statutory power. So that it is perhaps a little bit more narrow, and you may need to delve into what actual acts of parliament were passed and what law came into force. So that's it really for the two sort of main forms of contract use. JCT, as I was saying, generally you get your time but not money, but there is scope for money in certain circumstances. With the NEC, you've got your compensation event, which from a legal perspective opens the doors to both time and money, but you need to look at the facts on that particular job. And so what I wanted to do just finally was to touch on the experiences I've had since March. So in March, many subcontractors simply didn't turn up to work. They abandoned the sites without taking legal advice, and indeed in some circumstances turned up to projects which were closed. The developers, main contractors, whoever had decided to sort of preempt the actions by the government, and sites were closed. Large projects generally resumed within a week or so after sorting out the on-site procedures. Some projects didn't start for some time. You know, I'm aware of some small domestic jobs which just never restarted. And I've seen force majeure type arguments run by both contractors and employers, but frequently then dropped in favour of different relevant events, and often the contractor trying somehow to essentially change the different risk assessment method statements, the ways of working, as being a change or some sort of prevention by the employer. The most frequent compromise I've seen is actually reflected in what I was saying about the JCT, really, in that developers that I've seen haven't really been keen to punish the contractor. There's been a general sort of understanding that this was an unprecedented event, and so not looking really to hit them with liquidated damages or anything like that. So extensions of time, from what I've seen, have been pretty freely granted, but at the same time there is sort of, if you like, a political reluctance to allow any sort of profit, any sort of profiteering through the event. And so I've seen most money claims rejected, though there have been, you know, as there often are, exceptions, particularly where the contractor has had some on hire plant or equipment which they simply couldn't avoid continuing to pay, and for which they've got evidence of the money going out. So that's where I'm going to leave it, really. I think I've finished fairly sort of nice and early, allowing some time for questions. And so I'll put up my thank you side and hand back to you, Usman, now.
Thank you very much, Ben. That was really good. It seems like we've generated quite a bit of discussion in the comment section, which is great. So I might just dive straight into that.
Yeah, absolutely.
So we've got one which is extremely specific, but let's just go with that because that looks like the first question. So under clause 4.12, is the contractor entitled to additional prelims where extension of time is agreed?
So I'm going to have to kind of duck out of this one slightly, which is, it does come down to the facts. Say, let's just go back. So I think are we actually talking about the JCT's 421?
412. It doesn't say what particular contract, so let's just skip that then if it's not clear enough. So then we've got 421 of the JCT. Yes, it's been clarified in the comment box.
Yeah. So and this is really why there's often kind of, if you like, an incorrect tying together of loss and expense and extension of time, because particularly contractors will see it as, well, I've got my extension of time, now I'm entitled to my money, and we'll use a prelims rate, a weekly prelims rate or something like that. And so generally where there is a relevant matter that sort of matches the relevant event, then that is a good claim. You do get your additional prelims based on the delay, if the delay wasn't the contractor's fault. But A, that does need to be evidenced, and B, you do need to have that relevant matter. So I would say that it does really depend, and without trying to sit on the fence, I would say that the JCT leans very much towards no. You can have your time, but you can't have your money. And the only reason why I sort of equivocate a bit there is the last sort of points I put on the slide, which was that if the employer has done anything outside the norm of simply letting the work carry on.
Okay, great. I'll try and combine a couple now. So we've got who is responsible for proving it goes to the heart of the contract, and then as a sort of an extra, as a side question to follow on, as an advisor of legal process, what would you advise in terms of JCT or NEC contract to provide better cover for clients in terms of disruption to works, or let's just throw it out there, or another contract? I presume all have clauses that can be added or are already intrinsic within the contracts that can cover this.
Right. So what I'll do, I'll just skip back to who's responsible for proving it goes to the heart of the contract, and generally the rule is the claiming party has to prove. This is a civil law matter, and so the burden of proof is on the balance of probabilities. So in the case of, let's say, a JCT, then you would basically, it's going to be very likely to be the contractor that wants to get out of it, and it is for the claiming party to show that it does go to the heart of the contract. But it really does depend on basically who's benefiting from it, and ultimately a court adjudicator will decide based on the evidence. But yeah, generally it's whoever wants the money has to prove. And then the next one was about which contract, I would say. Well, it's one of the topics that I haven't really touched on in this talk, and I've used the JCT Design and Build 2016 as an example, but you almost never see an unamended JCT Design and Build 2016. They very frequently come with a series of amendments which are equal, or if not longer, than the JCT itself. So it does depend on the project. I would say that if the project is sort of more, how should I put it, kind of simple in nature. Maybe it's just maybe it's under 1 million, or maybe it's sort of 1 or 2 million, and you really, from both an employer's side and a contractor's side, don't want an awful lot of administration. I would go down the JCT route, because the NEC really does require both the parties to deal with problems as they arise via the early warning notices, via the compensation event mechanisms. So you do have to give a lot of resource to it. That being said, that sort of being forced to deal with issues as they arrive can be a very good thing. It stops disputes from, or generally stops disputes from sort of building up. So I'd say for perhaps more complex projects, larger projects, the NEC is the way to go. But of course, it does depend on the commercial issues on both sides.
Okay, great. I think we've got a couple which relate to the NEC, so I'm going to combine those two. So we have a comment made where Kevin has mentioned that they use the NEC on all projects, and they have a Z clause which mentions force majeure within their contracts, but it grants the contractor time but no additional costs.
Yeah.
And then as a follow-up, Paul has mentioned that if you have the Z clause in the NEC3 to meet the framework for force majeure, and you have X2, does X2 take priority over the Z clause?
So what I'll do is I'll deal with the Z clause. So the issue with the Z clause is that I don't know what it will say, because the Z clauses are by their nature bespoke. But what I will say is that before March, I was seeing similar Z clauses about Brexit. And then obviously March happened, COVID, etc. And now I see them kind of twinned together very frequently, where you'll have COVID and Brexit. And yeah, it's essentially the Z clause can say that, absolutely, that you can get time but no money. But you do have to be aware, because I've seen Z clauses which say you don't get time and you don't get money. And kind of, the response to that when I've pushed back has been, well, Brexit, the contractor knows about that. The contractor should have now got their procurement with any kind of products coming from Europe sorted out. And COVID, we all know about that now. So you're not going to get your time and your money, and you have to factor in the risk. And obviously then there's pushback from the contractor on that. So do be aware of Z clauses. It's not, they're not standard form clauses. They are bespoke, and you've got to read them individually. And so have I dealt with that point, or was there another one I've missed?
There was mention of the X2 clause, and whether the Z or the X2 would take priority in essence.
Well, that is going to be a lawyer's cop-out, where I sort of say, you have to look at the Z clause because of the way it's worded, and what you do sometimes see is effectively a Z clause with kind of new compensation events and the existing ones sort of stripped out. So as a gut feeling, I'd say the Z clause probably, but if they haven't chopped out the X2 and it does apply, then a contractor could run them both.
Please do keep bringing in your questions. We have about 5 more minutes. We do have another question, which is probably a bit too open, but please feel free to answer it as you feel fit, Ben. Out of interest, what your thoughts on the RIBA contracts, and particularly, do you feel as though that they are widely accepted by all parties?
I rarely see them, to be honest. I see the professional appointments quite a lot, often because an architect practice will have suggested them, and the developers been fine with them. It is simply not so much that they're defective, it's just that the JCT and the NEC have cornered the market, really. I think the JCT was there, certainly got sort of mass appeal early on, and the NEC now, is frequently effectively government backed. It's got to be used on certain types of projects, and between the two, they kind of cater for everything. And yeah, that's just, the RIBA ones are quite rare.
It'd be interesting to. I think before, I don't think I've seen any more questions coming, but I'll double check in a second. But it'd be interesting to understand what you've felt this year. I presume probably in a lot of cases we've probably had a lot of sympathy in regard to sort of the current sort of pandemic situation. So I presume even though contracts are written in a certain way which allow for certain things to proceed or happen, people have maybe stepped back and thought we might need to just sit down and talk about this sensibly rather than proceed to litigation, etc. What I'd be interested to hear your thoughts about that.
Yeah, absolutely, and that's really why I wanted to include this last side on what I've seen happen. You know, usually if I'm doing a legal talk about a case which has happened in the last 6 months or a particular legal concept, I don't really talk about our experience of it because, you know, who cares? Whereas over the last year or so, yes, the contracts may say one thing, but ultimately, you know, it's affected all sorts of people. And you know, I've got a client who rings me up probably every couple of days, and when this all happened, he pulled his guys off all of his sites. And he didn't call me in advance. He just did it. And I said, gosh, you know, you perhaps should have had a call with me because you know, looking at the law, you know, you might be exposed here. And he just didn't care because his perspective was he had to keep his staff safe and deal with his staff's concerns. And any inaction on his part would have had a more dramatic effect on his business than maybe being hit with, you know, a week or two of liquidated damages on some projects. Now, the reality is I don't think he was hit with any damages at all on any of the projects because A, a lot of other subcontractors had pulled off as well, and B, generally, there wasn't really a desire to punish the contractor. You know, a lot of cases have been let's get through this as best we can, and people have generally been practical and sensible about it. I do have one or two disputes which have rumbled on and of which COVID is an issue, but to be honest, they're not really about COVID and the delay. There were pre-existing relationship breakdowns on those jobs, and it's kind of been lumped in as just another aggravating factor, really. So, yeah, my experience generally is that you know, it has caused difficulties, but people have generally been commercial and proactive, and have realised that you know, ultimately you want your job finished. You know, you don't want a dispute. And you know, the issue I haven't really dealt with in this talk, and no doubt people will have encountered it as well, obviously, is that construction doesn't exist in a vacuum. And whilst we've got obviously the contracts that deal with construction, some of the problems which contractors have faced have actually stemmed from materials suppliers, a lack of materials, builders merchants being closed, etc. And so they've had knock-on effects to the construction industry, which is, you know, is more difficult to cater for in these contracts.
Okay, great. It's an interesting question being raised, which probably is a very much linked to this. I think again it's going to be a relatively simple answer, I guess. But do you feel as though contracts moving forward, much like Brexit, much like other things that have happened in the recent past, have altered the way in which contracts would be written? Do you feel as though sort of maybe standard clauses will be added, or do you feel as though, going back to what we've just raised, do you think that we'll be maybe making sure that force majeure is in most contracts, but they'll, in essence, if something this big does happen again, we'll potentially just need to go back to sensibilities?
Yeah, I think that's a very valid question, and to some extent, you know, perhaps myself was sort of guilty of it, you know, a little bit complacent in terms of the kind of the unforeseen events, what would happen if these large issues do arise. And you know, one of the things, of course, is you know, if I've been complacent, I've certainly not been alone with you know, force majeure not actually being defined in the JCT, for example. Now, probably thinking that that was such a a small chance to happen, then we'll devote the other pages of the contract to more important stuff. Whereas now, I don't know, I wouldn't be surprised if in the next version we see a more fully fleshed out sort of definition of force majeure. But this is one of the kind of joys, if you like, of being a lawyer, is that it is always moving. I mean, we've got Brexit, we've got COVID, but we've also had tragedies like Grenville, and there will be things in the future which impact both construction and the law that deals with it.
Just a final one before we wrap up. We've just had a question asking how, from your experience of it, I know we've spoken about contractors, but in regard to consultants, charter practices, etc., how do you feel as though this has impacted them? Have you seen much that has happened, or again, does it sort of revert back to, in this instance, it being sort of a sensible sort of approach?
That's a good question. Generally, I've seen less from the consultant side because there is that greater capacity generally, and many consultancies doing design to work from home. Now, that's not the case in all circumstances. Sometimes, it's only within the office that you'll have a particular technology, maybe the Revit model or whatever is only on the computers in the office. And so people have had to struggle with that kind of stuff. Also, there are, of course, consultants that go to site, employers, agents, architects, etc., quantity surveyors. There's absolutely no doubt that they've been impacted, but I think the difficulties that they have suffered, they've had greater capacity to work flexibly from home, etc., and deal with them, and they're not sort of hiring plant on site and that kind of stuff. So I've seen far less problems from consultants.
Okay, great. I'm just going to take over the screen. Hopefully it just switches. It's just to take it back to our upcoming events. So thank you very much, Ben, for doing this presentation. Hopefully everyone's found that of great use and answered some very pertinent questions and queries that you guys have. I hope Ben, I apologize to do this in front of everybody, but would you be offering any certificates for attending the event, or is that something you don't typically do?
It's not something we typically do.
Okay, fine.
What would be needed, is there sort of if there's a particular body or a reference number? No, we don't have that. If there's some sort of just general evidence, an email saying, that we did this talk on the particular day and we covered these things, then I'm perfectly happy to do that.
Okay, thank you. So if you guys have any obviously legal queries, and please direct it directly to Ben. He's from Quadrant Resolution in Bristol, very well experienced barrister, and now is in private practice. Very nice person as well. I know him.
Don't say that. That's the worst compliment for a lawyer. I'm a horrible person.
So just to go over the couple of things that we've got coming up is we've got Elim Housing on the 16th of December, which is Paul Smith, who's a former cabinet member of Bristol City Council, housing in particular. So it'll be really interesting. A large local authority, how they basically look to increase their building stock and so on, and now his move into social housing. So that would be very interesting. And then in January, when we come back from break, we've got on 6th of January is an international coach who will be talking about personal growth, CV, and job advice. So that's it from us. Thank you, everybody. Apologies if we didn't pick up all of the questions, but we have tried to, and hopefully everyone can get off and have a quick lunch before they get back to it for the afternoon. Thank you again, Ben.
Thank you, everyone.
Thank you. Goodbye.